Did you know that courts can write law? Did you know that some courts don't hear evidence? Did you know the Supreme Court really doesn't have a jury? You want to know why? Well, stick around, because I will tell you. I'm Brian, and it's time for another civics lesson. All right, everybody, we need to learn our civics. So share this, watch this, comment, like, repost, do what you got to do to get this out there, because civics videos are not the hot thing, and we really are going to need this in the next couple years. And with that, this is the story of our court system and case law. All over the U.S., we have what are called district courts. If you watch Law & Order, these are the courts you see. This is where the juries are, and they sit with the judges and hear evidence, plaintiff, the defendant, all that stuff happens in a district court. District courts from around the country will all be grouped together under one circuit court. All the district courts in this area will all be under the circuit court for this little region. So circuit court number 9 will handle all district courts for all of these states in blue. Circuit court number 11 will handle all of these states. Circuit court number 7, all of these states. All of these circuit courts are under the jurisdiction of the Supreme Court. Now let's be honest, you probably know all of that. Now let me teach you how they interact. I told you already that district courts are where jury trials are and that sort of thing. But did you know that jury trials cannot be held in circuit courts or the Supreme Court? Now, of course, nothing is true all of the time, but most of the time, circuit courts and Supreme Court cannot hear actual evidence. So let's talk for a minute about what district courts do. I posted a video the other day on the lawyer's definition of facts, and it explains this in great detail, but I'll try to give you a quick overview. By the way, the class where we learned a lot of this is called criminal procedure and involves a lot of drawing stick figures on whiteboards. Okay, so here's our story. 3 witnesses see a guy drive by in a blue car. They are able to identify the orange guy. A 4th witness sees a car drive by, not wearing his glasses, not really able to identify him. These 3 witnesses talk to the jury and say, we saw this guy in a blue car drive by. We saw him. This dude talks to the jury and say, I saw a car drive by and I saw him shoot somebody, but I didn't really see who he was. All right, so the jury is stuck here. Was that the same guy who shot the person? Unfortunately, here comes our 5th witness. Our 5th witness comes along and she says, this witness is colorblind and needs really thick glasses, which he broke to see anything. Now here, in our district court, the jury is known as the finder of fact. The jury is responsible for deciding what the facts of this case are. And the jury decides that indeed, these 3 people saw our guy drive by in a blue car. That really happened. But based on the 5th witness, they don't believe that this witness saw the same person drive by and shoot the dude. That, they think, was a different person. Therefore, they decide not guilty. Okay? The things that the jury has decided there are all facts. Were the first 3 witnesses believable? Yes. Was the 4th witness believable? No. Therefore, they believe the first 3, they don't believe the 4th one. Facts are always decided in district court. Usually they're decided by a jury, the finder of fact. Now, let's throw a wrench in this story real fast. Our 5th witness has 2 pieces of information. First, our 4th witness can't see very well and is colorblind. Second, our 4th witness used to date her and cheated on her. And she wants to tell all of that to the jury. Now, if she tells the jury that the 4th witness cheated on her, is that going to change the way they feel about the 4th witness? It might. So the judge reads the law. And according to the judge's reading of the law, a witness can testify about another witness's ability to see, maybe that their glasses were broken, but they can't testify about things that have nothing to do with the case, like he cheated on me 6 months ago. And so the judge says, you are not allowed to talk about that. And so the witness does not talk about that on the stand. Now, the question of whether or not that witness is allowed to speak is not a question of fact. The question of whether the person shot out of the car, the question of whether the car was green or blue, all of those are questions of fact. Questions about the law are questions of law. Questions of law and questions of fact are the two types of questions that are asked in a court. Questions of law, questions of fact. Questions of law, questions of fact. Two very different things. And only a judge can answer questions of law, whereas a jury can answer questions of fact. Why is this important? Remember how questions of fact are answered in the district court? Questions of law can be appealed to the circuit court. Questions of fact cannot. So let's say we take the question to the circuit court and we say, hey, circuit court, should our witness have been able to testify about her ex cheating on her? When the circuit court hears that case, they're not going to have any witnesses in, they're not going to have any jury in, they are just going to have the lawyers come in and argue the two sides of the law. They may look at facts of the case, they may look at some of the transcripts from the case, but they will only look at them on paper. They will not be able to ask any new questions. They will not be able to find any new facts. If they need to find new facts, they will send the case back to the district court to do that. So let's say we take the question to the circuit court and we say, hey, circuit court, should our witness have been able to testify about her ex cheating on her? And the circuit court says no. When a witness wants to testify about something that has nothing to do with the case, that will prejudice the jury, and that is a personal attack on another witness, we will not allow them to testify. When the court releases this answer, they're going to write it out as what's called an opinion. And it's going to say these three things. And from that point forward, this will become a law. We call it case law. It's a law that came from a case. And because it was written by the circuit court, it will apply to all of the district courts under that circuit court. That means that if the Fifth Circuit Court releases it, it will apply to every district court in Texas, Louisiana, and Mississippi. Now, let's say we don't like the answer again. We can appeal it again to the Supreme Court. But once again, the Supreme Court doesn't hear witnesses. All they have are the two lawyers come in and argue the two sides of the law. This is only about the law. And the Supreme Court will once again make a decision based only on the law. If the Supreme Court agrees, then these three things will become law going forward for all courts in the U.S. If the Supreme Court disagrees, then whatever they say in their opinion will become law for all of the United States. Or the court may decide not to hear it at all. If the court decides not to hear it, this has a couple of effects. First, it leaves this case in effect for that circuit court. And it sort of gives the other courts a bit of a heads up that the Supreme Court probably doesn't totally disagree. So if it ever comes up in front of them, they're probably better off doing the same thing. Now let me explain how this works practically. The new rule will look like this. If an ex-girlfriend comes into court as a witness and wants to talk about her ex-boyfriend who's also a witness and talk about him cheating on her, she cannot because it has nothing to do with the case, it will prejudice the jury, and it's a personal attack. That's what the law says. Now, what if, for example, there was another case where instead of being a personal attack, it was a professional attack? They said, we worked together and they didn't do their job very well. Well, as a lawyer, I might bring this out and say, look, I know this one's not a personal attack, it's professional attack, but the cases basically line up otherwise. I think it's the same thing, and I think you, the judge, should see them the same way. And then the judge will decide whether they agree or disagree. They will make a decision of law, and if I don't agree with their decision of law, I can appeal it, because decisions of law can be appealed. Decisions of fact cannot. And to be clear, some decisions of fact can be appealed, but not many. All right, thanks for coming with me, guys. It's another civics video. Please get this out there so people see it, and please learn your civics because this stuff is important. We need to understand how all of these things work. Thank you.